somebody that's claiming they own my debt, and then it coming back to haunt me. I want them to prove the right documentation, which I don't think they have. In fact, the bill of sale they sent, I mean, who is, Lynn Fisher? I could have made this in Microsoft Word. Do you know who Lynn Fisher is, or is this all the things they sent? The credit card statements have 2 purchases on them. And I mean, it's showing, it also says credit limit $2,500. So they want the, interest and extra charges and all that, which I was wanted to file a motion last time I talked to you for arbitration, which is also a clause in the credit card purchase agreement that they sent in these massive. I have an entire room full of these things that they've sent
from somewhere, maybe Mount Clemens. This is a claim for $3,109.06. We had a previous hearing in this case on November 17th. Mr. Pirro was here by telephone, and Naviat Francis appeared on behalf of the plaintiff at that hearing. I did allow 60 days for discovery. Plaintiff indicated they would be filing a motion for summary disposition. They have done that. Also, a lot of documentation has been filed regarding the history of this debt. And so this is set for a pretrial and motion for summary disposition. Ms. Olivier, what's your position here this morning?
My position is that the defendant did not deny any of plaintiff's allegations, just requested documentation, which he has been provided with in the interim. No answer having been filed to plaintiff's motion, plaintiff contends that the defendant did not present a valid defense to plaintiff's claims, and that defendant's answer does not overcome plaintiff's pleadings and proofs, nor has defendant demonstrated that a different amount is owed, and thus summary disposition under MCR 2.116C9 is proper because defendant failed to present a valid defense to plaintiff's claims. And further, that summary disposition under MCR 2.116C10 is proper because plaintiff's evidence proffered clearly establishes defendant's liability such that no genuine issue of material fact exists, and plaintiff is entitled to judgment as a matter of law. Plaintiff requests that its motion for summary disposition be granted for the full amount paid for, and that judgment entered for plaintiff and against defendant for the full amount paid for in plaintiff's complaint, plus costs and statutory attorney fee.
Because I couldn't figure out costs, and the order granting summary disposition just says summary disposition is granted. How much the damages are clear. What you're seeking is $3,109.06. What are the costs?
Costs are $75 attorney fee, $40 motion fee, and a service fee of $25.63 for total costs of $140.63.
Well, you left out the filing fee of $115.
Okay, I don't have that in front of me.
All right, let me add that. 75 attorney fee, $40 for summary disposition motions, $25.63. I couldn't find the service fee. It's alternative service plus 115. $255.63 in costs. If we add that to $3,109.06, we get $3,364.69. Mr. Pirro, that's how much they're asking for. What's your response here?
Well, I never argued the amount. Like she's saying, I never said anything about the amount. I was arguing that they needed to prove that they actually own the debt. I mean, obviously they're a debt buyer. They're not who I originally had the debt with. So instead of me, paying somebody that's claiming they own my debt, And then it coming back to haunt me, I want them to approve the right documentation, which I don't think they have. In fact, the bill of sale they sent, I mean, who is, Lynn Fisher? I could have made this in Microsoft Word. Do you know who Lynn Fisher is? Or is this, all the things they sent, the credit card statements have two purchases on them. I mean, it's showing, it also says credit limit $2,500. So they want the, interest and extra charges and all that, which I was wanted to file a motion last time I talked to you for arbitration, which is also a clause in the credit card purchase agreement that they sent in these massive. I mean, I have an entire room full of these things that they've sent.
This is the moment the courtroom changes. The judge stops being patient. This is no longer a warning. Every word now carries consequences. One wrong move and freedom disappears.
So,
well, there's even more.
Right.
Well, the fact of the matter is you didn't file anything, and they own this debt, and I'm about to grant a judgment for summary disposition in the amount of $3,364.69. They've provided a history of billing payment from your address.
Right, but did they?
Would you like to talk privately to Miss Olivier regarding the ability to make a payment on this? Or you want me to just order the judgment and then deal with that later?
I mean, this is the pre-trial technically, right? So.
Yeah, but there's a motion for summary disposition.
Right.
And if I grant the motion for summary disposition, the case is over. You owe $3,364.69. And then the question is any ability to pay it.
So what about the fact that it says I can have arbitration?
But you didn't ask for it.
Yes, I did. And things that I filed, I said
Where?
Also, the thing that we delayed this 90 days for, was that satisfactory to what they?
Yes, they sent you all this documentation
It was the
about.
same exact thing they had sent before. They added one page. So.
Well, in the court's mind, that's sufficient. You owe this
Okay.
debt. I'll
But to them, that's the real question. So.
Yes, you owe it to them. Credit Corporation Solutions.
Okay,
Inc.
well then you can file a disposition and I'll keep fighting it. So.
All right,
So I don't agree that I owe them specifically. So.
okay.
Because they actually bought the debt from somebody else. I mean,
Yeah.
they do this all day long, and I'm sure you know that. So
I do. I don't have to like it.
Right.
But yes, there's some of the largest, in fact, the largest filer of cases in Michigan are these
Right,
type of.
and they haven't reached out to me about wanting to settle, and
Well, I could put you in a room right now where you could talk to her
Okay.
privately regarding that. Do you wish to do that?
well, I mean, I'm sure they'd rather I pay the whole thing, but,
Well, Laura, could you open the conference room? I probably should have done it off the bat. Summary disposition is a concept that's not familiar to lay people. And you're doing the best you can. You
Right.
look some stuff up over the internet and you file this answer and they filed this stuff. There isn't anybody else asking for this money, just them. You can't pay the same debt twice. You don't dispute the amount owed.
mhm.
They've sufficiently established that they own the debt. So I'm not gonna make you pay it twice.
Right, if somebody else comes after me, right.
They won't have any standing.
Mhm.
So I'll let you speak privately with her, but I'm about to grant an order granting summary disposition.
Okay, so
And
last question would be if
Yeah.
you do the disposition thing,
Mhm.
is that how you set up a payment plan and all that sort of thing after that?
Yes, you can. Now, I can just do it and they'll garnish your wages and then you can file what's called a request for installment payments. But if we can reach that agreement, maybe we can do it right now. So I'll be here. Would you escort Mr. Pirro to the conference room and I'll put him in a breakout with Miss Olivier and we'll continue to work on another case, and then we'll see where we are with this.
Thank you, sir.
All right, I'll be right here.
Yeah.
All right, I gotta open a room. I have, did you get into the breakout room?
The discussion did not last long at all.
What's that?
The discussion did not last long at all. He's not interested in working out some type of payment arrangement.
All right, let me bring him back.
He got up and walked away, so I assume he's coming back into the courtroom.
The order is quite brief. Motion for summary disposition is granted. There's not a lot of space here. Did Mr. Pirro leave? The guy that was in the conference room. All right. He left. All right, thank you. All right, bye. All right, apparently didn't like what he was told. Damages. 3,109.06. Costs. 255.63.
Can you give me the breakdown of those, please?
$75 attorney fee, $40 motion fee, $25.63 service fee, and $115 filing fee.
Okay,
Equals
thank you.
3,364.69. I just wrote it in there. He acknowledged that he owed the debt. He just was in questioning who he owed it to. So I don't know why he's so upset about it. He admits he owes the money. He isn't going to have to pay it twice. I've established sufficiently for a motion for summary disposition that it was owed to you. Someone else isn't going to come in and sue him again for this debt. So his anger is misplaced, but he owes $3,364.69. I did explain to him his ability to file a motion for installment payments. I don't know whether he heard it or not, but I did tell him. At any rate, motion is granted. See order. Defendant left after brief breakout. He owes the money. If he start garnishing his wages, he can ask for a installment payment order. We'll discuss it further, but I do find beyond the standard required in 2.116 C9 and C10 both that he owes this money. All right, Miss Olivier, I'll see you again next time.
You want the
Thank you.
judgment submitted under the 7-day rule?
No, I just did your order. You submitted a summary
Okay.
disposition order and I put the numbers in it and we'll just use that.
Okay,
All right, thank you.
thank you. Have a great day.
Okay, we're working on it. Excuse me. All right, I think I've got who I need for our next case. Good morning, sir. Are you Onicio Moreno? You gotta unmute your phone. Mr. Moreno, I don't think I can. Can you hear me now, sir? Mr. Moreno? I
Say
can't
something.
hear you. You've got to unmute your phone.
Say something, Mr. Marino.
Yes. Hello. Can you hear
Okay.
me now?
All right, very good. All right, we're a little early and there's no harm in that. Then the next matter is Midland Credit Management versus Anicio Moreno. This is a claim for $4,426.75 plus cost, interest, and attorney fees. Attorney William Hill is here on behalf of Midland Credit, and Anicio Moreno is present by Zoom. This is the time for a pretrial in this matter. Mr. Moreno, after he was served with this lawsuit, filed a letter, which we accepted as an answer, indicating that he had been ill, was off work, went back to work, is working again, and would like to set up some sort of a payment plan to resolve this. Is that true, Mr. Moreno?
Yes.
All right, Mr. Hill, are you willing to go into a breakout room and discuss a potential repayment plan with this defendant?
Yes, General, I think that would be helpful.
All right, let me. All right, let me assign you each to the breakout room 1. Click the button that says join, and I'll wait here while you guys discuss the circumstance. All right, parties are put in the breakout room and I'll wait here.
The courtroom goes silent. The judge doesn't need to shout, because everyone understands what comes next. This isn't anger, this is control, and control is far more dangerous.
Static placement here. My entire 47-year career, people have come and people have gone, and some stay on and some move on, some retire. The time I've been here at the courthouse, between the prosecutor's office and the court, probably worked with over 100 different people, easily over 100 clerical staff, professional staff. Court alone is probably more than 50, 60. Maybe I'll add it up. Shana, do I have any bench warrant arraignments? No? Okay. Thank you, Christy. Christy says I don't have any bench warrant arraignments. we theoretically have a jury trial for Wednesday uh, with Sinquist Furlough. She has 9 cases. They were working on resolving the case, and I'm hopeful that it can be resolved. Tomorrow is a odd day of the month, so we have sobriety court again tomorrow. And 11 pre-exam conferences and a sentence. Lot of arraignments on Thursday. Ton of them. And Friday is the first Friday of the month, which will be very busy. I said, I think we had 70 cases. $75 cases, 60 defendants. $74 cases.
Excuse me, Your Honor.
Yes.
Mr. Marino might be having difficulty leaving the breakout room. We
All
worked
right, I'll
out.
bring him back.
Okay, great. We've got a
Takes 10
settlement.
seconds. All right, we're back. Mr. Hill and Mr. Moreno have had an opportunity to discuss this. Mr. Hill, what's our current status?
Your Honor, we've agreed to settle the case in the form of entry of a consent judgment. The parties have agreed to settle the case for the claimed amount of $4,426.75. No costs, no attorney fees. This shall be paid in installment payments at the rate of $150 per month, commencing February 20, 2026. So once we place this on the record, Midland will have to prepare and mail to Mr. Marino a judgment, as he does not have email So if the court perhaps could give us an adjourned date, I anticipate getting the judgment signed and presented to you for entry prior to that time, and we won't have to come back to court.
Well, we'll just do a consent order on the 7-day rule, and you can just submit the order. And if he doesn't object, I'll enter the order. Mr. Moreno, do you agree that you owe the amount of $426.75?
Yes, I do.
All right, they're going to waive the filing fee, the attorney fee, the motion fee, and the service fee, which will be several $100s. And it will be no cost. You agree to $4,426.75, payable at $150 per month, starting February 20th of 2026, and the 20th of each month thereafter, till the debt is paid in full. Is that the agreement that you reached?
Yes, it is.
All right, this would prohibit them from garnishing your wages or doing any other collection like a seizure. They could garnish a state income tax refund, but generally they do not once they've got a repayment plan. Mr. Hill or someone from Midland Credit is going to prepare an order and submit it under the 7-day rule saying that you owe that amount of money under those terms. You'll get it in the mail. You have 7 days to object. If you don't object, it will simply enter. I use this as an example. It's a bit of an absurd one, but let's say they put the decimal point in the wrong place and it says you owe 44,000 instead of 4,400. You would have 7 days to object to that. Or let's say they say the payment would be $250 a month and we agreed on $150. You have 7 days to object. Hopefully we would catch a mistake like that ourselves, but as long as the order says what we agreed upon here, you don't need to do anything. And we will enter the order after 7 days. Is that agreeable to you?
Yes. And so that means I'm not going to be waiting on anything in the mail to sign and mail back then?
No, you don't need to mail anything back unless you
Okay.
object.
Okay,
Now, do
copy
you
that.
still live on Vinewood?
Yes, sir.
All right, and you're back to work after your health issues. Where do you work?
I work for Coachman in Middlebury. Or Forest River took over Coachman, sorry. So it's Forest River in Middlebury.
Forest River took over everything.
Yeah.
All right,
Yeah.
very good. So you're back to work. You've got the ability to pay this. Let me tell you something else. If you want to pay early, you get a big tax refund, you sell a car, you want to just get this over with. Nothing prohibits you from paying the debt sooner. They're waiving all costs and attorney fees, and that is some benefit to you. Although you don't have to do that, as long as you make your payment of $150 per month on the 20th of each month, you're good to go. Does he have the payment information?
No, Your Honor, he doesn't. And as a matter of fact, what I explained to him, what typically will happen is that once we settle a case, they contact Midland by phone, and they have various ways to facilitate payment. They try to make it as easy as they can. Sometimes it's a automatic deduction from a checking account. But I don't handle that aspect of it, Your Honor. I'm really not even an employee of Midland. I'm just representing them. But
Yes, I understand. All right, does your phone number still end in 9218?
Yes, it does.
All right, they'll be contacting you regarding instructions on how to actually make the payment. All right, do you have any questions?
No, I mean, I did, but I think you answered it as far as paying it off early. Like if some months I could pay 300 instead
Yeah, there's nothing that
of
prohibits that.
150,
You
that
get a
is
bonus.
allowed.
Yes,
Okay.
sooner it's paid off, the better.
You know,
All
I
right,
have
Mr. Moreno.
one question.
All right,
Okay.
Okay. I'm going to email this back to Midland immediately and mark it urgent. And they're going to prepare a consent judgment. They're going to be somewhat confused if we don't have a defendant's signature. May we sign Mr. Marino's name to the consent judgment so they don't fiddle around with it, figuring, gosh, we need a signature.
yes, Mr. Moreno, you acknowledge here on the record that you agreed to these terms and conditions and they can affix your signature as consented on the record.
Yes.
Is that agreeable?
Yes.
All right.
Excellent.
Very good. All right, I'll let you get back to work. Thank you. I'm glad we were able to resolve this. Mr. Hill, I'll see you next time.
All
Okay,
right,
thank you.
guys.
Thank you, Mr.
Thank
Moreno.
All right, that finishes our morning civil docket. Well,
This is the line defendants never want to hear. The judge is done explaining, done negotiating. One more mistake, and jail becomes inevitable. This courtroom doesn't offer second chances.
all right, parties are put in the breakout room and I'll wait here. All right, this 9:15 matter will finish our general civil pretrials this morning. We have only one sentence on a driving suspended charge at 10:30. So it's pretty light morning, as I indicated. A lot of people got arrested this weekend. And I haven't been informed whether I need to see any of those people. If I do, I'll see them at 10:30. I'll hurry up and wait. Again, this card has been sold several times. I believe it was a Cabela's credit card. Yes, Cabela's Club, Capital One. We had a nice retirement little reception for Luke Laurie on Friday. He started his new career. Wish him the best. Autumn Kiefer has shifted to full-time magistrate. And our new probation officer magistrate starts, I think, tomorrow. There's no static placement here. My entire 47-year career, people have come and people have gone, and some stay on and some move on, some retire. The time I've been here at the courthouse, between the prosecutor's office and the court, probably worked with over 100 different people, easily over 100 clerical staff, professional staff. Court alone's probably more than 50, 60. Maybe I'll add it up. Shana, do I have any bench warrant arraignments? No? Okay. Thank you, Christie. Christie says I don't have any bench warrant arraignments. We theoretically have a jury trial for Wednesday uh, with Sinquist Furlough. She has 9 cases. They were working on resolving the case, and I'm hopeful that it can be resolved. Tomorrow is a odd day of the month, so we have sobriety court again tomorrow. And uh, 11 pre-exam conferences and a sentence. Lot of arraignments on Thursday. Ton of them. And Friday is the first Friday of the month, which will be very busy. I said, I think we had 70 cases. "75 cases, 60 defendants." 74 cases.
Excuse me, Your Honor.
Yes?
Mr. Marino might be having difficulty leaving the breakout room. We
All
worked
right,
on
I'll bring him back.
Okay, great. We've got a
Takes 30
settlement.
seconds. All right, we're back. Mr. Hill and Mr. Moreno have had an opportunity to discuss this. Mr. Hill, what's our current status?
Your Honor, we've agreed to settle the case in the form of entry of a consent judgment. The parties have agreed to settle the case for the claimed amount of $4,426.75. No costs, no attorney fees. This shall be paid in installment payments at the rate of $150 per month, commencing February 20, 2026. So once we place this on the record, Midland will have to prepare and mail to Mr. Marino a judgment, as he does not have email. So if the court